Okay, that's fine. Okay, that's fine. So at any point in time you're not hearing me again, please do well to break in and let me know. So yesterday we discussed obtaining an audit engagement. We talk about acceptance. We talk about the things that should happen for an auditor to reject an engagement. Please, it will be good if you're not talking, you can just mute to avoid any kind of interference so that people can get a. Hola, treasurer, please, can you mute, please? Treasurer, please, can you mute? Treasurer, if you are hearing me, please, you can mute. It's interfering. Thank you. So, breaking away from what we discussed yesterday, we'll go into tonight's business, and we'll be discussing joint audit. Now, having a joint auditor to join an engagement, what is the requirement? What you need to know? And these are some of the little things that you really need to pay attention, because when a question comes like this, it may look small, but you will have to convince the marker that you have the mastering of the subject matter. So a member whose firm is nominated as a joint auditor should communicate with all existing auditors and be guided by similar principles to those set out in relation to nomination as an auditor. Where it is proposed that a joint audit appointment becomes a sole appointment, the surviving auditor should communicate formally with the outgoing joint auditor. So we are talking about the audit of companies now, and sometimes an auditor can be nominated to join another auditor to become the auditors of a particular company. So the expectation is for you to be able to liaise as a new auditor coming in to join, nominated to join an existing auditor on a particular engagement of a company, of a client. You're expected to get enough brief to understand the aims and objectives of the audit, and to be able to be in tune of the principles set out in relation to your nomination as an auditor. So you cannot just come because you're a new auditor, then whatever the existing auditor has been doing becomes null and void. You are expected to work with them, get proper briefing from them, and understand the requirement to which the audit is committed to. Then, at a point in time, if by any chance the existing auditors are now exiting their appointment as auditors of that company, and you are now becoming the sole auditor of that company, then it is expected that this should be communicated to the outgoing auditor formally in writing, and you people should be on the same standing that yes, at this point, you have been exited by the shareholders. Of course, it is the shareholders that can terminate the appointment of an auditor. So at this point, I am going to be taking over as the sole auditor of this firm. So it's not something you go the back door. ICANN does not encourage that. So at any point in time, if you are a joint auditor, you must be working together with the existing auditors. Vacancy. A member whose firm is invited to accept nomination on the date of a sole practitioner auditor should endeavor to obtain such information as he may need from the letter alternative Where appropriate, the administrators of the estate or other sources. So what we are saying here is that if you are taking over from an auditor who has died, an auditor of a company who has died, it is expected that you should be able to get some information from the administrator of that auditor who is late now. So what this means is that there must be someone in charge that you can be able to meet. And when they say somebody, the administrator of the estate, it just means that somebody who preside over your affair when you're no more alive. And this is usually not written. So it is not something that you've written that, okay, if today I die, so person should preside over my affairs. It could be anybody whom they know that should be able to provide sufficient information regarding your details. So this person, we are saying that a new auditor who is nominated should be able to meet anybody on your behalf to get relevant information to continue the audit from where you have left. And if the administrator is not able to provide such information, the auditor can go about it in any manner in which it is able to get the information. That is where you see or other sources. So, but it is expected that as a new auditor invited to take over from a sole auditor who has died, you should be able to still inquire about the existing information to build on it so that you don't come and start afresh. There may be issues that the auditor have raised with those charged with governance or those responsible for the management of the business that you also need to be able to build upon. So if you come then and because a vacancy exists and you're taking over, all things have passed away, new team begin, then you may be giving a wrong audit. So you are advised to be able to still inquire to know that yes, there are some issues, or if there are not, it's fine. You now continue with your audit. Any question from there? Okay. So transfer of books and papers. A replaced auditor or advisor should transfer promptly to the client or to his successor after the latter has been duly appointed. All books and papers which are in his possession and which belongs to the client unless he is exercising a lien thereon on unpaid fee. Members should be aware that the courts have heard on lien can exist over books of documents of a registered company, which either by statute or by article or association of the company have to be available for public inspection. So what we're saying is that as soon as a new auditor is appointed, it is beckon on you as the outgoing auditor to be able to transfer all the working papers, all the documents related to the audit of the client to the new auditor, or you can as well hand them over to the client so that he avail them to the new auditor. However, there might be an issue. Maybe you have finished your work, you're not finishing on the good time with the client has not paid all your document and has not paid all your fee, and you want to hold on the audit report, you want to hold on some relevant information. Yeah, there is a clause there that in as much as you may do that, the law still require that is a commission. CAC still require that you have to make those information available for inspection should need arise. So additional work. A member invited to undertake recurring or non-recurring work, which is additional to related and relating to continuing work carried out by another chartered accountant or advisor should normally notify that other chartered accountant of the work he has been asked to undertake. So some persons have been doing the work before and you have been appointed now to undertake the same work. You should be able to also notify those who have been doing that same work. That is referring to an auditor, that yes, now I am on duty. And this will discuss something similar like that. That in as much as you are now appointed a new auditor, it's not something you should just come and exercise overall strength. You're expected to work with people who have been working on the audit before your appointment. So it is generally in the interest of the client that the existing auditor be aware of the nature of the additional work being undertaken. The existing chartered accountant will be provided with opportunity to communicate with the member to provide information, lack of which might otherwise prevent additional work from being carried out effectively. Additionally, such notification could affect the way an existing chartered accountant discharge his continuing responsibility to his client. So at any point in time, if your client is to give additional work to the one you have been doing, whether recurring or no recurring, it is expected that this will be notified, will be being written, that the auditor who is taking a new additional work will be notified in writing. So that should be duly served so that you are aware of what the client wants you to do in addition to the existing engagement. And this is actually in the best interest of the client, because if that is not done, the auditor may not be aware because he's not a magician. He will not be able to know the additional scope of work that you require him to carry out. So please, you may be able to on off your video if you're able, so that the quality of presentation will be better. So you can switch off your video, Mr. Nura. So notification should always be given to existing chartered accountant that there is additional work being added to what has been existing. Provision of all opinion on the application of accounting standard or principle clearly require particular sensitivity to avoid adversarial position, which an auditor and other chartered accountant wherever possible. So you're expected to be sensitive when you apply accounting standard on some issues that you think that other professionals may hold different opinion. So you have to be sensitive enough to be able to balance your reportage, whatever opinion you want to render. It is expected that you examine the sensitivity of the matter in as much as you're applying the accounting standards or the principles, because some persons may disagree with you on the subject matter. However, if this is done with due care and high level of professionalism, then you can be able to always prove why you've taken a particular position. But we are told here that you should exercise caution to avoid any kind of disagreement, the position that other chartered accountants or auditors may hold regarding such position. Any questions so far? And this has taken us to the appointment of an auditor. Appointment of an auditor. Yesterday we talked about this. That's section 104 of CAMA, Company and Allied Matter Act, Allied Matter Acts of 2020. Provide the procedure for appointment of an auditor, and also provided a procedure for removal of an auditor as well as resignation of an auditor. These are some of the things that you need to master under this chapter. Appointment of an auditor is very important. A removal of an auditor is very important. The resignation of an auditor is very important as well. And what you need to master here are the procedures that the company need to follow in appointing an auditor. the procedure to which the company require in removal of an resign from an engagement. So if you do not understand anything under this charter, please jot it down that you need to know the procedure to the appointment of an auditor, the procedure for removal of an auditor, and the procedure for resignation of an auditor. They are very, very important. So every company shall at each annual general meeting appoint an auditor or auditors to audit the financial statement of the company and to hold office from the conclusion of that until the conclusion of the next annual general meeting. At any annual general meeting, a retiring auditor, however appointed, shall be reappointed without any resolution being passed unless these three items happen. He is not qualified to be reappointed, or a special resolution has been passed at that meeting appointing some other persons instead of him, or providing expressly that he shall not be reappointed, or he has given the company notice in writing of his unwillingness to be reappointed as the auditor of the company. So the procedure here is that automatically at annual general meeting, the auditor can be reappointed by a simple resolution. So in any case, if the auditor is not reappointed, then one of these three conditions would have been in place. Whether the auditor, it has been discovered that the auditor does not qualify for reappointment. That is, maybe his tenure as an auditor has expired, as provided by CAMA. Or he has written expressly to the board or to the company that, no, I do not want to continue as the auditor of your company. Or a special resolution has been passed. And a special resolution are usually by the shareholders, because the directors do not have rights. In as much as they have some right to appoint the auditors, they do not have the right, retain the right to be able to remove the auditor. So it's only the shareholders who can be able to do that. And they can do that by just a special resolution. So those are the three conditions that must exist. Otherwise, the auditor is retained automatically at an annual general meeting by a simple resolution. So provided that where notice is given of an intended resolution to appoint some persons, to appoint a person or persons in place of the retiring auditor, and by reason of death, incapacity, or disqualification of that person, or all of those reasons, as the case may be, the resolution cannot be proceeded with. The retiring auditor shall not be automatically reappointed. So if any of these occur, whether the retiring auditor does not qualify, whether he is dead or he has become incapacitated, then in this case, he may not be reappointed automatically. If any of these conditions appear, cannot be appointed again. And this can fit into the first point where he does not qualify for reappointment. So where at an annual general meeting, no auditor are appointed or reappointed, the directors may appoint a person to fill in the vacancy. So this is where the director has the rights to be able to appoint someone who can fill in the vacancy. The company shall, within 1 week of the power of director becoming exercised, give notice of that fact to the commission. And if a company fails to give notice as required by the subsection the company and every officer of the company who is in default shall be guilty of an offense and shall be liable to penalty as the commission shall specify in its regulation. So when we are talking about the commission here, we are referring to CAC, which is the body that acts on behalf of CAMA. They are the one that have the local standing when it comes to Company and Allied Matters Acts. So they are the one that can institute a case against a company, withdraw or penalize a company or officers of the company for any misgiving. So subjects as hereafter provided. The first auditor of a company may be appointed by the directors at any time before the company is entitled to commence business by ordinary resolution with special notice. And auditors so appointed shall hold office until the conclusion of the next annual general meeting. So it is the right of the director to be able to appoint any person to fill in a vacant position of an auditor. But within 1 week, if the auditor fail to do that, in 1 week, if the auditor failed to exercise his rights and did not notify the commission, then anybody that is supposed to have taken that responsibility will be held liable according to the provision of CAMA. So the company may, at a general meeting, remove any such auditor and appoint in their place any other person who has been nominated for appointment by any member of the company and of whose nomination notice has been given to the members of the company not less than 14 days before the date of the meeting. So if the director fail to exercise their powers under this subsection, the company may, in a general meeting, convey for that purpose, appoint the first auditor, and thereupon the said power of the director shall cease. So if the vacancy exists and the director fail to exercise their rights, the company can convene for a special meeting and appoint a new auditor, and the power of the director will cease. So the director may fill any casual vacancy in the office of auditor, but while any such vacancy continue, the surviving or continuing auditor or auditors, if any, may act. So in case there are many auditors, we talked about the joint auditors now, for instance. So maybe one of the auditors have resigned, or for some reason, his position has become vacant. Then if there are any auditors remaining on the engagement within the time that such vacancy existed, any surviving auditor on the engagement will be allowed to act in the interest of the client. So in principle, the enumeration of the auditor is set by whoever appoints him. However, in practice, where the shareholder makes appointment, it is usual to delegate the board of directors to the power to set the auditor's remuneration. The directors are likely to be more familiar than the stakeholders or shareholders, with the nature and scope of work involved in the audit process. And so, the appropriate level of fee for that work, the board of directors may delegate the task of recommending or approving the audit fee to the audit committee. So in a well-established company, the director may be acting through the audit committee to be able to agree on a more reasonable feel that an audit can be carried out for a particular year. So, in as much as the shareholders have the rights as given to them by CAMA to appoint the auditor, they may not be able to know what the auditors are required to do, ranging from the scope of work and the requirements of the audit. So they may not be able to give a good view of what the remuneration for the auditor will be. So this power is delegated to the directors, and the directors can as well delegate them to the audit committee, who are expected to be people who have the knowledge of what the auditor will be doing on the engagement. I hope that is fine. So removal of an auditor under section 409, as amended 2020. In certain circumstances, the director are empowered to appoint auditors. However, it will not be appropriate for the director to have the power to remove the auditor from office. For example, it will be inappropriate for the directors to have the power to remove the auditors because there may be a disagreement between the directors and the auditors about an item in the financial statement or about the conduct of the audit. The directors could silence the auditor by just dismissing them. Clearly, it will be more appropriate for the director to recommend the appointment of new auditor to the shareholders and for the shareholders to decide. If the auditor resigns from the office, they are required to give their reason to the shareholders and notify the authorities of their removal. So this is what I have said before. In as much as the auditor has, the director has a right given to him by KAMA, he does not have the right to remove an auditor, because if he does have the right, when as member of those charged with governance or who are responsible for the management of the business, there may come a time that they will disagree on something that is substantial, that is material to the financial statement. And if the director has a right to remove an auditor, it's just for him to say, I sack you, and the matter goes. So KAMA is wise, and I can also uphold this statute to ensure that the auditor is well protected. And this is for you to maintain your fundamental principle of independence, so that you're not threatened by any kind of intimidation that the directors may want to pose on you, so that you are able to hold strong views concerning the operations of the company and management of the company, especially when it comes to financial statement that will be issued out to the public out there, or that will be sent to the shareholders, creditors, or those who are interested in the company. So if the auditor resigns from office by any, they are required to give their reason to shareholders and notify the authorities of their removal. I think we don't need to say much about that. As when you're resigning your former engagement, you should be able to notify those who have engaged you. That is that. So in Nigeria, it is the ordinary shareholders who are able to dismiss the auditor by passing an ordinary resolution with special notice at a general meeting. So you can just go and underline this in your book. Underline this in your book. It's very important. In Nigeria, how does the removal of an auditor happens? And we are told that it is the ordinary shareholders who are able to dismiss the auditor by just passing an ordinary resolution with special notice at a general meeting. So if I can frame a question for you here, and they ask you who has the power to remove an auditor, the nail on the head straight before you now put any other thing. You should be able to say it is the ordinary shareholders, and they can do this by an ordinary resolution, by just raising of hand, vote, voice vote, or whatever means, with a special notice at a general meeting. So when this occurs, the company shall within 14 days give notice of the facts in the prescribed form to the commission, and if a company fails to give the notice as required, the company and every officer of it who is in default shall be guilty of an offense and liable to penalty as the commission may specify in its regulations. So if at any point in time you remove an auditor, the law provides that within 14 days, you write to the commission. We are referring to a CAC. When we talk about the commission, we refer to CAC. You notify them within 14 days that Mr. XYZ is no longer the auditor of our company. And officers who are responsible for doing this, if they do not do within the stipulated time, they can be cut off with the law. So we now talk about the resignation of an auditor. I told you before that an auditor retains the right to resign, and this is stated in subsection 412 and 413. The auditor can decide to write to the company and say that I'm no longer interested in the audit and I wish to resign. However, the auditor may choose to resign during this process of office, period of office. The reason for this might include a consistent lack of integrity is demonstrated by management or those charged with governance. A significant fee remains unpaid. The audit firm can no longer maintain its independence. So there is a threat to independence, which is primary and key, following a corporate action. So maybe the company decides to buy shares in that, maybe the auditor decides to buy shares in client's company, or for so many corporate reason, they can no longer maintain their independence. It is advised that they resign their position as an auditor of that firm. Then the client is no longer profitable for the audit firm. However, company law provides certain safeguards to ensure that the shareholders are made aware of any relevant circumstance relating to the auditor's resignation. So if there are situations that occur, it is expected that the auditor notify the shareholders of the company before his resignation. But under section 412 and 413, CAMA provides for procedure for an auditor to resign. And these are some of the reasons that an auditor can resign. And when I started my class today, I told you that even if you have not gotten anything at all from this charter, you should also be able to know that what will be required in appointment of an auditor, what will require in removal of an auditor, and what will be required in the resignation of an auditor. So these are things I expect you to jot them down, look at them carefully, and form a little note and have it handy, so that the day before your exam, you browse through and everything comes back and you know that you're ready for the exam. But these are some of the things you cannot escape. So the procedure for resignation of a current auditor are: the resignation should be made to the company at its registered office in writing. So you are not expected to serve resignation notice to the company to each branch. For instance, now you are an auditor of Zenith Bank, just for example, and you want to resign. You're not expected to tender your resignation to any branch office. It has to be at the registered office. The registered office address, that is where the address that the company registered with CAC, that is where you are expected to submit your letter of resignation. The company should submit this resignation letter to the appropriate regulatory authority, which is the CAC in this case. The auditor should prepare a statement of the circumstances This is set out, this set out the circumstance leading to the resignation. If the auditor believes that these are relevant to the shareholders or creditors of the company, if no such circumstance exists, the auditor should make a statement to that fact. So for any reason, if an auditor is resigning, we have stated 4 reasons thereabout. It is expected that you should state any of the reasons that exist, any of the circumstance or condition that exists that you want to exit the audit of a particular company. And if none of them existed, it is also expected that you state that fact to stakeholders, which could be shareholders, which could be creditors, and any other person, even the regulators. So the company should send this statement to the commission within 14 days of receipt. The third point there say the company, upon receiving of that statement from the auditor, must send it to CAC within 14 days. All persons entitled to receive a copy of the company's financial statement, principally the shareholders, unless the commission rules that the auditor is seeking to defame the company with needless publicity. Otherwise, every other person, the shareholders, who are supposed to obtain financial statement from the auditor, should be made to serve a copy each. Then the auditor may require the directors to call a meeting of the shareholders in order to discuss the circumstances of the auditor's resignation. So where the auditor suspects that he cannot be able to just exit like that, it is expected that he should make the director to convey a meeting where he can state the position at the meeting with the shareholders. So he can discuss this, and maybe his concern may be considered, then he can now change his decision. So if default is made in compliance with the above provisions, the company and every officer of it who is in default shall be guilty of an offense and liable to penalty as the commission shall specify in its regulations. Any questions so far? Any
I think
question?
I think there is no any question. The class is going on well, and the presentation is well understood and is very clear. So I
Okay,
guess
that's fine.
Please, I want to
That's
ask a
fine.
question.
Please go ahead.
In a situation whereby the auditor doesn't have concrete evidence or doesn't have concrete evidence on why he's resigning, it can be based on he's not longer interested, he doesn't want to do it. He's not being threatened or anything. Will the auditor be questioned by any other attempt or so?
Okay. So the auditor can always have a reason for resigning. So resignation of an auditor does not mean that he holds evidence against the firm. Can you see my screen? I want to
Yes,
show
sir.
you something. You can see
yes, you
my
can.
screen. You can
Yes.
see the resignation of an auditor. So these are the
Yes.
primary reasons. These are the primary reasons that an auditor can resign. So if the auditor thinks that the work of the client is no longer profitable to him, maybe he does not have joy in doing the work again, that is a ground for resignation. So you do not need evidence to provide that you want to resign, except for where you say that maybe for the second reason, where they say significant fee remain unpaid. Here you may require evidence to show that yes, you have worked for so contract engagement signed, but this is the only amount you have received. You have not received other payment. But for every other reason, you may not need evidence to show that the business is no longer profitable for you. And I believe this is where the auditor will always hold that the client no longer audit is no longer profitable for its firm, and they may want to resign. Just like you working in an organization and you decide that you no longer want to give your service to that company, Do you need evidence to tell anybody why? You can even decide to say you don't want to, you want to go and be with your family, isn't it? So the auditor can just write that he wants to disembark to pursue other opportunities. So you do not need evidence to provide against the company, except where you make a claim, that the company is owing you money, or the company has demonstrated, the directors of the company have demonstrated lack of integrity by not complying with some certain things. Yesterday we said that if you observe that there are certain issues with the system, the accounting system of the company, you should call those charged with governance, those responsible for the management of the company, to discuss on them. And you should make them sign in writing that they are committed to resolving some of the issues before you accept the engagement, isn't it? And we were told that we should be able to review those commitments to see whether they have been complied with or not. So for the number one reason, it could be that you have given the auditors, you have given the client, the directors, a commitment that they need to meet up with. And over the time, your review has shown that they were not able to do that, and they deliberately refused to do that, which culminate to lack of integrity. Then on that ground, you do not need too much evidence to anybody. You can show that yes, they have signed on also dates that they were going to do XYZ. Today is this, but they have not done XYZ. So on this ground, you can no longer continue because your license may be at the risk of being withdrawn from you, from the profession. So these are some of the conditions that will exist that an auditor may want to resign on appointment. Any other question? Or are you okay with that?
Yes,
Can
sir.
you come again with the appointment of an auditor?
Okay. Okay. So the appointment of an auditor shall be at annual general meeting,
Earlier, let's go after someone can sleep.
right?
For what?
Every company shall at
Tell her to mute. Tell her to
annual
mute.
general meeting appoint an auditor. So the procedure to that is that what automatically, when an auditor is appointed, he can be reappointed at every other annual general meeting, except where the auditor say that he does not want the appointment again, or where the directors feel or the shareholders feel, or for any reason they think that the auditor is not qualified for reappointment, or any other.
Let's go outside.
Please, can you mute? Mr. Victor, please,
Please
can you
tell
mute?
others to
Let
off
them
the
mute
microphone.
to
Please
voice
let them
control,
off the
please.
microphone.
It's very important that you mute if you have to discuss something that is not related to what we are doing, because others want to get something and they may lose a point if you're interrupting. So I was just discussing the appointment of an auditor. I said that every company shall at each annual general meeting appoint an auditor or auditors to audit the financial statement of the company. And if these auditors are appointed, automatically they can be reappointed unless they are not qualified for reappointment, or there is another special resolution stating clearly that they should not be reappointed, or they have written and given notice on their unwillingness to be able to continue or to be reappointed. Otherwise, once they are appointed at the annual general meeting, they remain the auditor of the company. And we also discussed that since it is at a general meeting they are appointed, they cannot be removed by the directors. It also has to be the shareholders who appoint them that will be able to remove them by an ordinary resolution at a general meeting with a notice of at least 14 days. So the appointment of an auditor under section 401 of CAMA as amended 2020 provide that every company shall appoint their auditor at an annual general meeting, and he can be reappointed at every other annual general meeting unless these three conditions I've just mentioned occurred. Are you okay with that?
Yes, sir.
All right.
Yes.
Thank you. Okay, that's fine. So feel free to ask your questions and we'll handle them in that way. So the next thing will be agreeing. Go to page 70 of your study pack. Agreeing the terms of audit engagement. That is ISA 210, International Standard on Audits, number 210. So the preconditions are stated there, and the engagement letter, what is contained in the engagement letter is also stated there. So the objective here is that the objectives of the auditor as per ISA 210, agreeing the terms of audit engagement is to accept or continue an audit engagement only when the basis upon which it is to be performed has been agreed. This is done by establishing whether the precondition for an audit are present. So what I'm trying to say here is that before an audit will happen, before an auditor taking a new engagement, remember the charter is talking about obtaining a new engagement. So what we are saying is that there are preconditions that must happen before an auditor will accept a new engagement. And it is advised that until all those conditions are met, the auditor should not accept. And these are the conditions. You have to establish whether the precondition for an audit are present. One, confirming that there is a common understanding between the auditor and the management. There is an understanding that it is my work as an auditor to check between your papers to confirm what you have done over the period of time and express an opinion, to tell you the scope, the time commitment, the number of items I will sample, and what of you that will be required for me to be able to pen down an opinion as per your financial statement over a particular period of time. That common understanding must be established between the auditor and the management of the company. Then, to establish if the precondition for an audit are present, ISA 210 require the auditor to establish if the financial reporting framework
Hello. Hello,
to be
sorry, I'm
used.
raising my hand. Hello.
Okay.
Good evening. Sorry, what's the name? What's the name? Asa, right? Can I
Gabriel,
address
you
that?
can call Gabriel, it's fine.
Okay, Gabriel. So the screen you are sharing, I mean, I don't know, it's not corresponding with what you are explaining.
Okay.
What is currently showing is procedure for resignation.
Okay, let me reshare then. Sorry, thank you for that observation. Just give me a moment, let me reshare. So can you see that? Is it moving?
Yes, it is.
Okay. So this is where we are. I say you can refer to your study pack if you have one, page 70. So we are talking about precondition. The objective of the auditor as per ISA 210, agreeing the terms of an audit engagement, is to accept or continue an audit engagement only when the basis upon which it is to be performed has been agreed upon. This is done by establishing whether the precondition for an audit are present and confirming that there is a common understanding between the auditor and the management. So to establish this, if the precondition for an audit are present is as contained in ISA 210, require that the auditor should establish if the financial framework, reporting framework to be used in the preparation of the financial statement is acceptable. For instance, IFRS or IPSAS, obtain the agreement of the management that it acknowledges and understands its responsibility. That is a premise. So what this is trying to say is that you must obtain acknowledgement in writing that the management of the company has agreed to their responsibility, that it is not the work of the auditor to prepare financial statement. Rather, it is the work of the management to prepare financial statement. And that it is the only work of the auditor is to check the facts and issue an opinion. So, for the preparation of their responsibility for the preparation of financial statement, for internal control to ensure that the financial statements are not materially misstated, to provide the auditor with all relevant and requested information and unrestricted access to all personnel. So the responsibility of the management sprang from preparation of financial statement, maintaining a robust internal control that prevents the financial statement from materially being misstated, and also providing unhindered access to the personnel of the company. So the auditor have unhindered access to any other person in the company for any reason, should they want to inquire about any subject matter as contained in the financial statement. It could be on depreciation, it could be on inventories, it could be on cost of goods, it can be on sales, it can be on anything. The auditor should be given that unhindered access to be able to assess every other person in the company with respect to requesting information as regards to the audit of XYZ. The auditor is required to refuse the engagement where a limitation on scope is posed by management such that he, the auditor, would be unable to express an opinion on the financial statement, or the financial reporting framework to be used in the preparation of the financial statement is unacceptable. So we have just given an example of IPSAS, International Public Standard on Accounting, Statement on Accounting Standard, or the International Financial Reporting Standard. If, for instance, now the management is introducing an entirely standard to which they want the auditor to prepare the financial statement, you know that is going against your call, because you're expected to prepare financial statement based on International Financial Reporting Standard or the International Public Statement on Accounting Standard. So these are the things that guide you. So if the financial statement are prepared on another basis, then you can reject that kind of engagement because it does not conform to the required standard. Then the only exception allowed by ISA 210 for accepting or continuing the engagement to the above is when the law or regulation require the auditor to do so. So if there is any injunction by court of a competent jurisdiction, or in case of Nigeria, there is a notice from CAC mandating the auditor to carry out the audit of a client based on the requirement that is provided that is contrary to what the auditor would have carried out with respect to IFRS or IPSAS, then the auditor can be able to continue but that is an exception. It does not usually occur. Then engagement letter. Having accepted an appointment as an auditor of a client company, the audit firm shall submit an engagement letter to the board of directors of the client company. The engagement letter can be seen as the basis for the contract between the company and the auditor. So just the way when you've gotten an employment, you receive an offer letter. Engagement letter also serves as an offer letter. So this letter is the basis to which the audit firm or the auditor can now assume a contract between him and the company. So at every point in time, for any kind of engagement at all, there must be an audit, there must be an engagement letter, because that is the only basis to which you can sue the firm if, in case they refuse to pay you after your work. But if you do not have anything to show, then you may be working for free. So it is very important for you to know the contents of an engagement letter. These are very simple questions that can come. They will ask you to state the contents of an engagement letter. And it is very simple. The engagement letter will ordinarily comprise of the objective and the scope of the audit, the responsibility of the auditor, the responsibility of the management, identification of the underlying financial reporting framework, the reference to the expected forms and content of any report to be issued. So in that letter, if you like, call it job description, will be stated therein. And this will become a guide between the auditor and the client company, so that both of them are guided on what they need to do. So in addition to those above, the auditor may feel that it is appropriate to include additional points in the engagement letter, such as more details on the scope of the audit, such as reference to applicable legislation, regulation, international statement on audits, and ethical pronouncement. So the auditor can include some clauses that will help serve as a guide to what the client company should understand, in addition to their responsibility and the responsibility of the auditor, that these are some of the issues that the auditor has referenced. And this is to say that there are basic requirements that the auditor need to follow in order to be able to issue an opinion on the financial statement. So the fact that because of the inherent limitation of an audit and the inherent limitation of internal control, there is an unavoidable risk that some material misstatement may not be detected, even though the audit was properly planned and performed in accordance with international standard on audits. So what we are saying here is that the auditor can also state this, and this is a kind of skepticism. You're saying that, yes, I know that I have planned for this audit properly, I've obtained all that I want to do, but for the fact that there is inherent limitation, because it is what is in the system therein that you are going to edit. So if the numbers were not correct, but they computed them in a manner that was correct, for instance, there was any kind of creative accounting that the auditor is not able to detect, or based on the sampling that the auditor think it is okay to be able to issue an opinion. This does not mean that at the end of the day, the audit may, or the financial statement is immune to any kind of misstatement. No, this can still happen. So the auditor will include the fact that for the fact that there are limitations, maybe based on internal control or other issues, there may be misstatements that the auditor may not be able to detect. So you need to state that fact in the letter so that the client company do not see the auditor as a magician who is able to see the things that he is not even provided before him. Then arrangement regarding the planning and performance of the audit, including the composition of the audit team. The letter will contain how the audit has been planned, how the audit will be carried out, and the team composition. So in this case now, who is the lead auditor and who are the supporting staff for the engagement? It is stated in the letter. So when you are addressing a correspondence, you know the auditor in the team that you address to. Then the expectation that the engagement will provide written representation. So you tell the management that they should know that at the end of this engagement, there will be a written representation. The statement will be issued, and on this basis. So the basis on which few are computed and any billing arrangement. So you could tell them that, okay, because you're going to do this work for also number of hours with the also number of resource person, that is the auditors on your team who are also qualified like this, then you're able to tell them that this is on this basis that you're billing them to that effect. So all these things are stated in the letter. A request arrangement to acknowledge receipt of engagement letter and to agree to its term. So you request therein that the management should acknowledge that they have received your letter and they are also willing to comply with its provisions. Then arrangement concerning the involvement of other auditors, experts or internal auditors, sorry, or other staff of the entity. You will tell them that also matter, you may require the service of a lawyer, a tax practitioner, or any other person that you think can be able to provide useful inputs to achieve the aims of the objective of the audit. The aims and objective of the audit. The auditor is asked, will have to include that in the engagement letter as well. Then any restriction of the auditor's liability when such possibility exists. So you issue a skepticism to show that you will not be held liable for any kind of liability that may occur for XYZ. You articulate the reason why the liability should be restricted to some extent, because you are not a magician, you are working on data provided, information provided, or information available to you as an auditor. Then explain why the auditor might wish to include each of the following points in the engagement letter. So, for example, now, the basis to which the fees are charged, you outline your timetable, formal acknowledgement of the content of the letter, arrangement for the involvement of the client. So this is like a question, and you can see the way they answer it here. So you can see from page 72 of your study pack, they are testing, they say, explain why the auditor might wish to include each of the following points in the engagement letter. So these are some of the, I can say, review questions that you can see. And when you see questions like this, don't ignore them. Go through them, read them, and understand. And this is what we have just read. The answer they provided here, basis on which fee are charged to ensure that there is no misunderstanding, for example, that more senior staff cost more than that of the that time is money. This may help to encourage the client to provide as much assistance as possible and not to insist that all work is carried out by more senior members of the team. So if the client know that maybe you all the team you have deployed, more of the team member composition are senior staff, then you should know that the payment of the senior staff is more expensive than when you want to pay the junior staff. So the client company is expected to have the knowledge that, yes, if you want to have senior staff on the team, then you should be willing to pay more. So the higher qualification or the higher grade of staff you have on your audit team, the more money you may want to charge. And of course, there are times that auditors are enlisted on different engagements, so they have to share their time to be able to cope up. As a manager in a typical audit firm, you cannot be on one engagement. Like those working in the Big Four, you cannot be on one engagement because you'll be underused. So you have to be on different kind of engagement, and your time is as precious as money. So you cannot go and put your head in one client's company who is not paying even up to your salary. So it has to be a staff whose salary are commensurate to what the client can pay. And these are the basis to which you can put up the fee. They outline timetable to ensure that the client would be prepared for arrival of the audit team. For example, draft financial statements supporting schedule of all ready and key staff available and not on holiday. If necessary, the audit timetable could be changed at this stage. So what we are saying is that you should draw a timetable, and this should signal the client company that all the people who are responsible for the drafting of financial statement, who will support with maybe some of this schedule like asset schedule, inventory, sales schedule, any kind of schedule, any kind of information at all that you will need. These key persons are available within the time of the audit. You discuss this with the management, and if these key persons are not available, you can even decide to change the timetable at that stage so that you come when they are available to respond to important questions. The informal acknowledgement of the content of the letter to ensure that the directors cannot later claim that they did not understand the scope of the audit and their responsibility for the financial statement. So you make them to acknowledge this so that they don't come and issue a disclaimer that they are not aware of their responsibility as regards to the financial statement. An arrangement for the involvement of the client staff to ensure that the client is able to plan for the involvement of the necessary staff and that they are available at the required time. So these are some of the things that an auditor will do or will include in an engagement letter. So recurring audits. Any question on engagement letter?
Yes, sir. There is a question I want to ask. Thank you very much.
Okay, that's
Sir,
fine.
I want to ask about the engagement letter. Is it
Okay.
the auditor that is going to write the engagement letter, or the company?
Okay, it is the auditor.
Is the auditor? Okay.
Yes, the engagement letter is coming from the auditor. Yes.
Auditor. Thank you.
Yes.
Continue now, sir.
All right. Thank you. So the engagement letter is issued on the initial appointment as auditor. May state that its provision will apply to full future annual audits until it is revised. However, ISA 210 requires the auditor for recurring audit to assess whether circumstances mean that the terms of engagement need to be revised. The management need to be reminded of the existing terms of the engagement. The ISA suggests that the following factors may indicate that the above is appropriate. Any indication that the entity misunderstands the objective and the scope of the audit. Any revised or special term of audit engagement. A recent change of senior management. A significant change in ownership. a significant change in nature of or size of the entity's business, a change in legal or regulatory requirement, a change in the financial reporting framework adopted in the preparation of the financial statement, or a change in other reporting requirements. So, the initial letter of engagement, however, sometimes may be required that the auditor state that some things may happen that they will require them to revise the audit engagement. So you need to remind the management that if any of the following reasons, some of these items I've just mentioned now happen, then there will be need for you to revise your terms of engagement. That is why we say the international standard on audit suggests that the following factors may indicate that the above is appropriate. That is, management need to be reminded of the existing term of the engagement. So if there is change in ownership of the business, then the auditor will write a reminder letter to telling the management that this and this has been the condition, the terms and condition of our engagement with your company. If there is change in senior management, that is referring to directors or those charged with management of the company, the auditor can as well revise his engagement letter or write a reminder letter to tell them that there's an existing engagement between them and the client company. And these are the terms and conditions therein. And the management has also a sole responsibility as regards the financial statement. So these are some of the things that can happen that the auditor will need to issue a revised engagement. So they may ask you what and what will happen that will make an auditor to revise its engagement or send a reminder letter of engagement to a client company. So you can just tell them that if the ownership of the company has been changed or the senior management has been changed or any special term regarding the engagement has been revised, maybe the tenure of the auditor has been elongated. Instead of maybe doing 1 year, they have now decided that, okay, he should cover other things, or maybe it's a group company now, they have added more work or subsidiary to him. So you see that that would have expanded the scope of his work, or there is changes in the requirements by the law, or there is any new standard regarding reporting framework, then the auditor can write a reminder letter to tell them about the current engagement. Then acceptance of a change in the terms of engagement. The entity might, in certain circumstances, ask the auditor to change the terms of the audit engagement. This might result from a genuine change in circumstances or from a misunderstanding as to the nature of the audit as originally requested. However, it could result from a situation where the auditor is unable to obtain sufficient appropriate audit evidence regarding a material item. The entity might then ask for the audit engagement to be changed to a review engagement to avoid a qualified opinion or a disclaimer of an opinion. So let me ask a question. Do you understand the meaning of a qualified opinion? Basically, in audit, we have two
Fair and free
and
of
unqualified.
material.
You said?
I said to be fair and free of material.
That is a qualified opinion.
Yes.
Somebody supports that answer.
I think I didn't really get the question very well because maybe the network was really picking me up.
Okay, let me take it again. They say the entity might then ask for the auditor, ask for the audit engagement to be changed to a review engagement in order to avoid a qualified opinion or a disclaimer of opinion. I now ask that, what do you understand by a qualified opinion as an auditor? What do you understand by a qualified opinion? Can anybody try? I want to hear from you.
Okay, I think if I will try
Okay.
qualify opinion as an auditor, that's a
Yes.
substantial opinion, meaning that will be reviewed so that you will not come and say this is not what I I stated at the beginning. So meaning that should be the final word that is coming from you.
And normally, opinion is given at the end of the
Okay.
audit. But I want
Sorry.
to understand the meaning of. I want
Let
to
me
get
try.
something from you.
Let me
I want to
try.
try.
Okay,
Okay.
go ahead.
Qualified opinion is when an auditor is limited in assurance. Is limited in his assurance that he has the that is he has expressed his opinion, but he doesn't have concrete evidence that this information should be true or fair.
Yeah. So I thank you very much for that answer, and for every other person who have tried. You all tried well, but I prefer the last answer. So for a
A
qualified
qualified
opinion,
opinion is
okay,
probably the auditors is not being influenced by the board of directors, so it's free from bias. That's what I feel like.
okay, thank you. But you know that at the end of the financial audit, it is expected that the auditor should issue a true and fair, to check whether the financial statement present a true and fair, it is stated true and fair, right? So
Yes.
I am telling you that when the opinion is a true and fair one, then it is an unqualified report. But where the report is qualified, then it is mean that in the course of the audit, the auditor has discovered something that that does not conform to the expected standard. That is why they say to avoid a qualified opinion or a disclaimer. The auditor will say that for every other reason, every other thing, it is fine, except for this one. I am not sure that it was supposed to be this. So the auditor will say, for every other thing, everything is fine. But for this one, I am not aware and I did not agree to it. I don't know if you understand. So a qualified opinion means that the auditor has discovered something that is unresolved to his satisfaction and is trying to tell anybody who will go through the financial statement that on so particular item, oh, I did not sign, I did not agree. But when you say an unqualified opinion, then it is mean that the financial statement present a true and fair view as required. Do you understand that?
Yes.
So I know that people usually have a misgiving when it comes to qualified and unqualified opinion. Just take it that an unqualified opinion is the positive one for the company, but a qualified opinion is a negative one against the company that something they did not do well is detected in the financial reports or financial statement, and the auditor has reservation. I hope that is clear.
Yes, sir.
Yes.
Okay, thank you very much. So ISA 210 require the auditor to consider the justification for the request and whether it is reasonable. If the auditor consider that it is a reasonable request, then revised term should be agreed and recorded. So if the auditor is unable to agree to a change of terms, he should withdraw from the engagement and consider whether there is any obligation to report the circumstance to those charged with governance, owners, or regulators. Oh, we have come to the end of this chapter. So maybe we can just take the review questions, then you can ask your questions. Then after that, we just take the review question and try to be our mind, then see how we can close. It's already 11 o'clock. Any questions so far?
No,
Sir, my question is not about the audit. Like in exam, audit ISA
Yes.
stuff. Will
Yes.
they like ISA 200? Will they just say explain what is ISA 200? Will they like tell us like the title of it in the exam?
No, no, no. No.
So
I've
what?
never seen a question that asks you to explain ISA in exam. The question I can see is that they will say that according to ISA so and so, maybe they will
Yeah.
say ISA 401 now, appointment of an auditor. You are now required to state the procedure required in appointing an auditor. They can never ask
Okay.
you, no, they
Okay,
can't
sure.
do that. Yeah, it's not like university exam. It's a professional exam. They want to test your mastering of the subject matter. They want to
Yeah.
test your real understanding of what the issue is. That is why you don't write ICANN the way you write university exam. You write it
Okay.
with understanding. Yes, put it in your words, but bring out the major points to support your argument. Make it convincing to the owner to the marker that yes, you really understand what you're saying. Like for instance, now they're asking, before moving to the next chapter, check that you know how to explain the commercial legal process around obtaining and accepting a new audit appointment. So this is a very straightforward question. If you had joined this class yesterday, explain the commercial legal process around obtaining and accepting a new audit appointment. Then explain the ethical consideration with respect to client and engagement acceptance and changes in professional appointments. Then describe the process for resignation and removal of an auditor. I have said that before, right? These are your suggested questions. Describe the requirements of ISA 210 with respect to the precondition for accepting appointment as an auditor and also for setting up the engagement letter. So this is the question you just asked now. This is how the question can always come.
Okay, sir.
Yeah, so this is how the question can always come. These are some of the questions. What mechanism is used by the shareholders to remove an auditor? We have discussed that this night. I was telling somebody to underline. Do you remember that? Look at it. Special resolution with ordinary notice at a general meeting. Special resolution with general notice at a special meeting. Special resolution with general meeting at an ordinary meeting. Special resolution with special notice at a general meeting. So can somebody choose this answer for me? I think when I was presenting, I even show my screen.
At the
I
general
show my
meeting.
screen. Sir?
Option D.
It's at the,
Thank you very much. So you can see, these are some of the questions you should play around with. And when you have done playing around with this, you can be rest assured that you have actually prepared for the exam. So I will be happy to take your questions. Otherwise, they even provide answers. So otherwise, we call it a quit for tonight and maybe resume next week. I think it's next week we'll be having
Sir,
our
please,
next
I don't
class,
if you
right?
don't sir, please, if you don't mind, can we treat the chapter review?
The charter review. Okay, the charter review
That's
is
the
advised
question.
that advised that after getting the general knowledge, you're able to go through your part to be able to answer the question. But I can only give you an overview of what the question requires of you. You understand that? So, for instance, they are
Yes, sir.
asking you to explain the commercial legal process obtaining and accepting a new audit appointment. So yesterday, when I started this class, I told you that you should have it at the back of your mind that there are two things that can happen for an auditor to accept an engagement or not. At the initial, there is a there are commercial reasons and there are also ethical reasons. On the commercial reasons, you should know that an audit practice is a commercial venture, and that means that it's a business, and the auditor is set out to make profit. And of course, he is set out to maximize profit, isn't it? So at every point in time, if you receive an engagement offer and you know that you will perform this engagement at a loss, then you shouldn't jump into such an audit. Do you understand? Then the process could be that you have to draft out your proposal. When we talk about the tendering process, it is expected that you will respond to a proposal, you will articulate your view, the required number of staff you are going to use, the time commitment that you use on the engagement. You state them there. Then you bid your proposal and you win an engagement. But we are saying that for the fact that it's an audit practice, it is also a business. If not for any reason, you will have to pay your staff. You will need to pay your office rent. You will need to buy internet. You will need to subscribe to your internet. So you cannot be doing a work at a loss. So you should have a reason that after the audit, there should be commercial or there should be benefits or there are inflows that will come into your account as a business. So on the basis of commercial reason, you may jettison from an audit engagement. Then the legal process here, just talk about your tendering process or how you should be able to respond and then accept an audit engagement. Then explain the ethical consideration, which with respect to client and engagement acceptance and changes in professional appointment. So I gave the basis for ethical reasons yesterday that at any point in time, you are not expected to carry out your work as an auditor in a manner that put the profession in disrepute or put a chartered accountant in disrepute. You're not expected to pay commission or accept a fee. You're not expected to advertise your skills. So these are the ethical issues. You're expected to always act in the best interest of the client and the profession. You're not expected to carry out any kind of acts that pose a threat of self-interest at any point in time. So anything that appears to be a threat, ranging from independence, fundamental principles of duty of care, integrity, confidentiality, these are ethical issues. You must run away from them. So as long as you're sure there is no any threat to ethical issues, ethical consideration, you can accept the audit. Then describe the process for resignation and removal of an auditor. We have done that today. We say that the auditor has the right to resign if he thinks that the audit engagement is no longer profitable for him, or he is unable to settle scores with those charged with governance, or he thinks that, I think I have that here. Let me go back there. There is lack of integrity from those charged with management and governance. He has money with the client that is not paid, or his independence is being threatened, or the client is no longer profitable for the audit firm. Then, the last question, describe the requirements of ISA 210 with respect to precondition for accepting appointment as an auditor. So these are the preconditions. The answer is in your book. You just need to look at it. These are the preconditions. These are the preconditions. The objectives of the audit as per ISA 10, agreeing to the terms of audit. Establish whether the precondition of an audit are present. So these are the preconditions here. For the preparation of financial statement, the internal control, the responsibility of the management, and all of those things. Unrestricted access, and there is an understanding between you and the management. And there is a basis to which the financial statement will be prepared. Establish all these preconditions as required by ISA 210. Then what again? Do we still have questions? Okay, those are the questions. So this is already 11:13, and if you don't have questions, we assume we have come to the end of tonight's class.
I must
Then
make
we'll
this.
resume when it is appropriate. But if
I
you
must
have
make-
questions, I'm happy to take them. Yeah.
I must make this comment, not a question.
Okay.
Yes, the comment is I'm impressed with the presentation and also very well articulated. I know I have a physical class that I attend, but I believe I've missed out because most of us that are doing audit are those that are maybe from foundation. So we
Okay.
have audit here. So actually, it's very, very clear. I was thinking I was going to even meet the class again tomorrow because I'm just coming back from the office, but I felt, I have to wait for this class today. And thank you so much for making it with us. I believe very well. God will bless you. And
Thank you. Thank you. Thank you. You're welcome.
yeah, we'll all come back and share our testimony here.
Amen. That is a prayer.
Yeah, thank you
That's
very
a
much.
prayer. So it's a forward ever journey, no looking back.
Yeah,
That is
thank
the
you very much.
courage. So I will be dropping my LinkedIn name. You can check me up on LinkedIn. You want to
Okay.
connect with me on LinkedIn, so I will just submit it now
Okay.
on the chat box.
Okay.
So you can join me and send me a chat there. You can always hook up.
Okay.
So yeah, you can check me on LinkedIn up, and you will see me. So thank you, everyone.
Thank you so
Thank
much,
you
sir.
for your active participation. I wish you all the best.
Thank you so
I hope to meet with you next week. The director, that is Yusuf Kabil, will direct us on the next topic we are going to take. So I will post the topic and you will read ahead so that we can be able to discuss when we meet in our next class. Thank you, and do have a wonderful night rest. So like I said, you can check on the chat box and pick my LinkedIn handle and we can connect there. Thank you.
welcome.
Thank you.
Yeah. All right. Thank you. Bye-bye. Good night.